Well, welcome. Thank you for coming to this book talk on unconstitutional constitutional amendments published by Oxford University Press earlier this year. We're extremely, extremely honored to have invited the author himself, Dr. Yaniv Roznai, from Roznai Law School of the Interdisciplinary Center, Perstia, to speak to us. Thank you very much for coming all the way, Yaniv, and congratulations, first of all, for publishing this excellent book. You realize how excellent it is after you talked about it. It really is an outstanding piece of scholarship. And second, on your promotion, Yaniv has recently been promoted to senior lecturer equivalent to associate professor. So congratulations. And also father of 3. So great responsibilities right now. So many congratulations. Many of us in this room would already be familiar with Yaniv and his work, but I see that Yaniv has attracted some students and some members of the public as well. So for those who don't already know Yaniv, Yaniv specializes in comparative constitutional law, constitutional theory, and public international law. He is an elected board member and secretary general of the Israeli Association of Public Law. He has been a postdoctorate fellow at the Minerva Center for the Rule of Law Under Extreme Conditions, the University of Haifa, and at the Hulsa Global Law School, New York University, as well as a visiting researcher at the program in Law and Public Affairs, Princeton University. This is an outstanding book. It provides a very clear structure for looking at the issue of unconstitutional constitutional amendments, and it propounds a theory for us to rationalize the idea of constitutional amendments, to rationalize how is it possible for a constitutional amendment to be unconstitutional, as well as how is it possible that courts could have powers of striking down constitutional amendments. It's thoroughly researched. For those who've read the book, you might discover that the bibliography itself is 41 pages long. So it's thoroughly researched. It's also clearly written, accessible to non-experts to the subject. So really, congratulations. Without further ado, maybe, yes, David. So when we have an expert in the audience, so David.
No, this has nothing to do with. This has nothing to do with the substance of the book. I just want to add that this is, my understanding is that this is one of the fastest-selling law monographs in OUP history. It was published a couple of months ago. It's already in its second reprinting. So.
And I was told that it might be published in Spanish as well. So really, congratulations on the cover of the book. You could see. Distinguished scholars from around the world raving about the book. So Mark Tischnet from Harvard, this is a work of fundamental importance to everyone concerned with the basics of constitutional theory. So congratulations, and without further ado, I'll hand over to you to present your thesis.
Thank you. Wow, thank you very much, Ryan. Thank you for this opening. I think I can only ruin it from now on, so I might just stop here. No, I'm joking.
No.
And thank you very much, David. I think that my mother probably bought about a third of the sales.
She did send me some food, actually.
Okay, so I think with that I'll start. Thank you very much, Gar, for inviting me here. It's my first time at the University of Hong Kong, and it's a great pleasure and honor for me to be here. So yes, the main question or topic of the book is the idea of constitutional amendments, or what I term constitutional unamendability. And by constitutional unamendability, I refer to certain limits or restrictions on the ability to amend constitutions. In other words, there are certain types of constitutional subjects, such as principles, rules, or institutions, that are resistant to their formal amendment through the constitutional amendment procedure, and this is the main topic of the book. Now, in the book, I try to describe 3 trends of global constitutionalism, or trends of constitutional unamendability. The first trend, and most obvious one, is that I term explicit unamendability. Nowadays, if you look at national constitutions, you often find certain provisions that are being regarded as explicitly unamendable. So the most famous example is Article 79.3 of the German Grundgesetz, the German basic law, that states that human dignity and the basic principles of the constitutional order are eternal. They're untouchable. Yeah, they're unamendable in a way. Now, the idea of having an eternal constitution itself is by no means novel. John Locke, when writing the Constitution of Carolina in 1669, stipulated in the final sentence that it shall be and remain the sacred and unalterable form and rule of government of Carolina forever. Describing the entire Constitution as unamendable, I think derives either from ascribing it to a superhuman source, such as the Bible, or simply from the Constitution maker being inflicted with such arrogance and belief that he had achieved the apex of perfection. And nowadays, such delusions of unamendable ground no longer exist, but you can find certain provisions within the constitutions that are regarded as eternal or unamendable. Now, what I've done is looked at constitutions, national constitutions, from 1789 until 2015, just to see if I can find a certain trend. And what I find is quite interesting, actually. So if you look at this collection of over 700 constitutions, in the first wave of constitutionalism, of world constitutionalism, after the French and American Revolution, 1789, let's say, until World War II, less than 20% of world constitutions included such unamendable provisions. If you look at the second wave of global constitutionalism after World War II and until 1988, already almost a third of the constitutions that were enacted in that period include unamendable provisions. And in the third wave of constitutionalism, the post-1989 until 2015, now what we have is that over half of world constitutions that are enacted in this period include unamendable provisions. So, to me, it seems that nowadays having an unamendable provision in a constitution is becoming a universal fashion, a symbol of modernism, if you like, and an important feature of global constitutional design. So that's the first trend that I'm trying to describe in the book. And if you want, I can later elaborate what are exactly the things that are being protected in these provisions. The second interesting trend is that even in states where the Constitution does not include such unamendable provisions, in other words, it is silent about this issue, courts around the world have recognized the core of basic principles, which is implicitly unamendable. And the most famous example that is often cited is the Indian one. So in the famous case from 1973, the Indian Supreme Court, in the case of Kesavananda, declared that the power to amend the Constitution does not include the power to alter the basic structure or framework of the Constitution so as to change its identity. Now, obviously, this is very interesting because the Indians, rooted in British tradition, where did they get this idea of limitations on the power of Parliament to amend the Constitution? So basically, they got it from the Germans. A German scholar named Dietrich Conrad traveled from Germany to India in 1965 and gave a lecture on implied limitations on the ability to amend the Constitution. And his presentation later served when people argued before the courts about the scope of the amendment power. So this is a very interesting story. So the Indian Supreme Court created what is now termed the basic structure doctrine. There's a certain basic structure of the Constitution that is implicitly protected from constitutional amendments. Now, this idea did not remain in India, but migrated to other neighboring and other jurisdictions, such as Bangladesh, Pakistan, Kenya, South Africa, Taiwan, Colombia, Peru, very recently Belize. Courts in all these jurisdictions have declared that there are certain constitutional principles which are implicitly protected from amendments. And this is the second major trend that I'm trying to draw in the book. The third one concerns the judicial enforceability of constitutional unamendability. It is one thing to claim that the amendment power is limited. It is quite another thing to claim that these limitations should be enforced through substantive judicial review in courts. The obvious problem is, if such limits are being enforced or able to be enforced by courts, then we shift the locus of constitutional change from these political institutions that have the power to amend the constitutions to the courts, and thereby making courts the final arbitrators of society's values, if you like. Now, interestingly enough, in 1921, Edward Lambert, the French scholar, published his book, Le Gouvernement des Juges. In this book, Lambert claimed that American style of judicial review, the common law style of judging, and the elevation of individual rights above social values would eventually lead to judicial review not only of ordinary legislation, but also of constitutional amendments. Now, at the time, this idea that courts will be able to review constitutional amendments amazed French readers who naturally object judicial review, or traditionally object judicial review. And 7 years later, after Lambert published his book, Carl Schmitt, the famous or infamous German jurist, in his Verfassungslehre constitutional theory book, claimed that Lambert's core thought is correct and will sooner or later show its practical significance. Now, I find these two statements really important because these two predictions were spot on. Nowadays, judicial review of constitutional amendments is an existing practice in many states around the world. Brazil, Turkey, Austria, the Czech Republic, Germany, to state just several cases. Not only that courts review constitutional amendments, but they often declare constitutional amendments to be unconstitutional. To give two recent examples, so in 2008 in Turkey, the parliament enacted two constitutional amendments concerning headscarf ban in universities. They wanted to abolish headscarf ban in universities, but these amendments contradicted the sacred or unamendable principle of secularism, laicite in the Turkish constitution, and the Constitutional Court declared these amendments to be unconstitutional, and it invalidated these amendments. A year later, in the Czech Republic, the court invalidated a constitutional act that was ad hoc, a particular constitutional act, and the court invalidated this constitutional act, declaring it to be contrary to the idea of the rule of law, which is unamendable in the Constitution. So in these two cases, the courts have declared constitutional amendments as unconstitutional. Now, the very idea of an unconstitutional constitutional amendment seems prima facie paradoxical. If an amendment is being enacted according to the constitutional procedure, then it becomes part of the Constitution. If it's part of the Constitution, it has an equal normative value as other parts of the Constitution, and therefore it cannot be, on its face, unconstitutional. Even in our everyday language, when we talk about unconstitutionality, we refer to certain legal norms that are inferior to the Constitution and contradicted, not to norms that carry the same normative value as the Constitution. So, if you go according to the ordinary rationale, constitutional amendments carry the same normative value as other constitutional provisions, and according to the principle lex posterior derogat priori, a later norm should prevail over a conflicting earlier norm. So how can we have this idea of unconstitutional constitutional norms? Now, in the book, I basically argue that by clarifying the main concept, the nature of the amendment power and its scope, is the first step for undoing this or solving this apparent paradox. Let's move on to the more theoretical aspects of the book. So the main argument, the first is comparative one, and is to describe a wide pattern of the constitutional behavior, the imposition of limitations on the amendment power and its enforcement through judicial review. The second argument is that this global trend basically rests on a solid theoretical ground. And here I move to the theoretical parts of the book. The first part deals with the nature of the amendment power. Now, in order to understand the nature of the amendment power, one has to go back to Abbé Emmanuel Joseph Sieyès and his famous distinction between constituent power and constituent power. In a speech before the National Assembly in 1789, Sieyès declared, "Une constitution suppose avant tout un pouvoir constituant." And likewise, Schmitt stated that the Constitution does not establish itself. We need a constituent power that is behind the Constitution. We need a constitution-making power. So Sieyès is basically making a distinction between constituent power and constituted power. Constituent power is the extraordinary power to form or found a constitution. It is independent of any constitutional forms and restrictions. In contrast, constituted power is the ordinary power that's being created by the Constitution. It is an ordinary limited power which functions according to the forms and mode that the nation grants in positive law, executive, judiciary, legislative, etc. Now, on this account, the distinction between constituted and constituted powers is imperative for my investigation. If the amendment power is conceptualized as a constituent power, then it is unamendable. It is free from any restrictions. If, on the other hand, it is being conceptualized as a constituted power, then it must be regarded as a limited power. However, I argue that this specification is extremely thorny when one has to assess the nature of the amendment power. And one is it. Why is it? On the one hand, the amendment power expresses the ultimate constituent power. If the people control the Constitution, then arguably, through the amendment procedure, they also control other constituent organs. Therefore, the amendment formula represents the people's constituent power. This is what the German call competence, the competence regarding competence. On the other hand, the amendment power is a legal competence defined in the Constitution and regulated by it. Now, since it is a legally defined power originating in the Constitution, it cannot ipso facto be a genuine constituent power. So, as Stephen Holmes and Cass Sunstein write, the amendment power does not fit comfortably into either category. It inhabits a twilight zone between authorizing and authorized powers. It is simultaneously framing and framed, licensing and licensed, original and derived. So, in light of that, I argue in the book that the amendment power is basically a sui generis power. It is neither original constituent power, not an ordinary constituted power. And in order to better explain it, I argue that it should be regarded in terms of delegation. And in order to do that, I revive an old French distinction between original and derived constituent power. And this was first developed in debates in 1791, in debates of the French National Assembly. And through the years, two main approaches were developed concerning the distinction between original and derived constituent powers. There were first those formal positivist French jurists such as Carré de Malberg, Georges Bourdeau, Georges Vedel, who claimed that the main distinction between original and derived constituent power is a formalistic distinction. Original constituent power is exercised outside the forms prescribed in the Constitution, like a revolution or a coup d'etat, and in contrast, derived constituent power is exercised according to the procedures prescribed in the Constitution. That's a very formalistic distinction. There's another school of thought that promotes a more substantive distinction. That is, for example, Olivier Beau or Carl Schmitt. So, Carl Schmitt made the distinction between Verfassung and Verfassungsgesetz, the Constitution and constitutional laws. According to Schmitt, through constitutional amendments, you can change almost every provision of the Constitution, but as long as you maintain the identity and continuity of the Constitution in its entirety. This is very much resembles the Indian basic structure doctrine. So basically, according to the substantive theory, it's not a matter of form, but of substance, the scope or ability to change the constitutional document. Now, in the book, I argue that basically these two schools of thought are not mutually exclusive, but actually mutually reinforcing. And in order for them to coexist, the amendment power should be comprehended in terms of delegation. So basically, delegation should afford the legal framework, even if not always consciously articulated, to rationalize the state of affairs surrounding the nature of the amendment power. And the story is that through the amendment provision, the people, in a way, allow a constitutional organ to exercise a constituent authority, the authority to constitute constitutional laws. When the amendment power amends the Constitution, it uses a legal competence delegated to it by the primary constituent power. It acts as agent of the people. And having a principal-agent relationship, the delegated amendment power is subordinated to the principal power from which it draws its legal competency. Therefore, the delegation of amendment power inherently entails certain limitations. As Thomas Paine wrote, all delegated power is trust. Therefore, the amendment power that acts as trustee of the people in the original constituent power must be limited in a way. Because the amendment power possesses only fiduciary powers and must be, therefore, intrinsically limited by nature. If you want to better maybe understand it, there is a vertical separation of powers between the original constituent power of the people and the delegated amendment power. The theory of delegation says that the amendment power by nature must be limited, and now let's move on to see what kind of limitations are applicable to it. The first and more, let's start with the easy case, with unamendable provisions. So the amendment power that acts as a delegated power has this power as a trustee of the primary constituent power. Therefore, it must obey those terms and conditions as stipulated in the trust letter of the Constitution. In other words, unamendable provisions create a normative hierarchy between constitutional norms. And just as constitutional law prevails over ordinary conflicting law, a constitutional provision that is established by the higher constituent power prevails over constitutional provisions that are established by the amendment power. And when resolving a conflict between the two, what prevails is the principle of lex superior derogat inferiori. And so it doesn't matter if the amendment was enacted after the original provision. What's important is their source of enactment. And if the source is a higher authority, that of original constituent power, then it prevails. So in other words, unamendable provisions or eternity clauses are valid and should be recognized as such. The more difficult case is that of implicit limitations. Now, here I argue that the theory of delegation includes two types of limitations. The first implied limitation is the most basic. The constitutional amendment power cannot be used in order to destroy the Constitution. And it is here Thomas Cooley's metaphor, I think, is astoundingly clear. The fruit grower, Cooley wrote, does not forbid his servants from poisoning the apple trees. So some things are obvious. We don't need to write them down in the Constitution. Yeah? So likewise, when it comes to the constitutional law, the amendment procedure is basically the internal method that the Constitution makers provide for the Constitution's self-preservation. By destroying the Constitution, the delegated amending power undermines its own raison d'etre. So to amend the Constitution as to destroy it and create a new Constitution would be an action ultra-virus, a power that the people have not delegated to the amendment authority. The second limitation derives from the first one, but it's one logical step forward. The amendment power cannot be used in order to destroy the basic principles of the Constitution. So according to my understanding, every Constitution consists essentially of a set of principles which determine the totality of the constitutional order and make up the spirit of the Constitution and its identity. If you destroy the basic principles of the Constitution and you basically you change the Constitution and make a new Constitution instead, then it's the same result as destroying the Constitution. So these two actions are prohibited according to the theory of delegation. I think that the idea that the amendment power is intrinsically limited finds some textual support. And that appears in the literal meaning of the term amendment. So literally, the Latin word amendere means to correct a fault. Yeah, like the Hebrew term tikkun. It implies construction rather than destruction. So according to the textual rationale, amendments must operate within the boundaries of the existing constitutional order and its foundational principles. When someone gives me a document and I tell him, well, you need to amend it, I don't mean to destroy the document and have a new one, but to correct the existing document. Now, obviously, the textual argument itself is not very strong, but taken together with the larger theoretical framework, then it can provide some further support. Am I with time?
Maybe 5 to 10.
5 to 10, that's perfect. Okay, good. So I'll just move on to the enforcement. I think that once you correctly understand the nature of the amendment power as a delegated legal power, then you can also explain judicial review of constitutional amendments. So prima facie, judicial review of constitutional amendments is undemocratic in a way, right? Because you move powers from those political elected authorities to the courts. However, if you look broadly on the theory, then by enforcing constitutional unamendability through judicial review of amendments, you actually protect the people's primary or original constituent power. Because what you tell those political or institutional authorities, certain things, certain decisions you cannot make. You need to give it to the people in their capacity as original constitution makers, if you want to do that. So basically, through judicial review, you protect the vertical separation of powers between constituent power and amendment power. Now, obviously, a constitution can explicitly stipulate that the court has the power to review constitutional amendments. This is the case, for example, in Ukraine or Romania, but most constitutions are silent on this issue and do not provide any guidance. However, comparative constitutional law reveals that courts around the world have declared that they possess the authority to review constitutional amendments and give some effectiveness or legal teeth to constitutional unamendability. So, for example, courts in Germany, Brazil, and the Czech Republic have declared such authority even without explicit legal competence in the Constitution. Before I conclude, I want to say another word about the effectiveness of unamendable provisions or constitutional unamendability. The way I see it, unamendable provisions are like a lock on the door. We don't really need a lock on the door if all the people around us are honest people. If no one will try to make an entry to my apartment, I don't need a lock on the door. I also don't need a lock on the door, or the lock on the door will not be effective against a well-equipped burglar that wants to break into my home. The lock on the door will not deter him or hinder it. And the same applies for the Constitution and for constitutional unamendability. Eternity clauses or unamendable provisions are not required when all the actors around us are playing according to the rules of the game. If everyone's playing according to the rules of the game, there's not a problem. And we also don't need it, or it won't be able to stop a true extra-constitutional revolution or a coup d'etat. It simply won't be able to stop it. To give you just one recent example, the Ukrainian constitution includes a provision in provision 157 states that the territorial integrity of Ukraine is eternal, unamendable. So what? If Putin wants to take Crimea, then this unamendable provision obviously would not stop. Therefore, I object terming these provisions eternal provisions or eternity clauses. Nothing is eternal. In that respect, the Portuguese terminology is quite interesting. In Brazil and Portugal, they term these kind of provisions clausula petrea, Petra's clauses, stone clauses, or rock clauses. This is very interesting because on the one hand, it points to the rigidity of these constitutional provisions, but on the other hand, even rocks cannot withstand the volcanic outburst of the original constituent power. So I think this is quite suitable. In the book, I refer to these provisions as unamendable because they only limit the constitutional amendment powers. They cannot limit original constituent power. So I want to conclude, and I want to conclude with a story. I have here photos of three handsome gentlemen. You might know some of them. So in 1948, the famous Austrian logician Kurt Gödel, this handsome guy, applied for an American citizenship. So Gödel, being a very serious scholar, studied American history, and he studied the American Constitution. And one day, he called his Princeton friend, mathematician, Oscar Morgenstern, and he calls Oscar Morgenstern, and he tells him, listen, Oscar, I've studied the Constitution, and I found, to my distress, a loophole in the Constitution that would allow destroying all the democratic institutions and the establishment of a fascist regime never intended by the founding fathers. This is a very relevant story, actually. So Morgenstern tells him, listen, calm down, don't worry about it, this would never happen, and most importantly, don't tell it to the judge, the examiner in the naturalization exam. But he was persistent, and he called his other friend from Princeton, Albert Einstein, and told him about this difficulty, and likewise Einstein tried to relax him, and both Einstein and Morgenstern accompanied Gödel to the examination, to the citizenship exam. And they gave a testimony, a character testimony, not such bad people to have, right? And then the interview continued. And the judge asked Gedel, well, Mr. Gedel, where do you come from? And Gedel said, well, I'm from Austria. And what kind of a regime did you have in Austria? And Gedel said, well, it was a republic, but it was later changed into a dictatorship. And the judge said, well, this is very bad, but this could never happen in this great nation. And then Gedel stood and said, yes, it can, and I can prove it. And the judge silenced him, and everything went quietly, and he got the citizenship, went well. But what was this loophole that Gedel found in the Constitution? We never know, because he never wrote it down. But scholars that have studied Gedel and studied law and logics suppose that the thing that worried him most was the amendment procedure. Article 5, the amendment procedure of the US Constitution, does not include any substantive limitations. So in theory, you can amend, if you get the majority required, you can amend all the other provisions of the Constitution. You can amend the amendment procedure itself and state, for example, that every future presidential decree will have a constitutional status. All right? So the aim of the book is basically to argue that Gedel should not have been worried. The amendment power, by its nature, is limited, whether explicitly or implicitly. And once you understand the true nature of the amendment power as a delegated and limited authority, then the alleged paradox behind the idea of unconstitutional constitutional amendments disappear. Thank you very much.
Thank you very much. Can I abuse my position as chair to ask the first questions? I'm sure David and others in the audience would have lots of questions. But I do have a couple of questions. I can see analytically why it would be useful to distinguish the original constituent power, the amendment power, and ordinary constituted powers, like ordinary legislative powers. But what are the practical implications of seeing the amendment power as sui generis involving delegation rather than just a mere constituted power? Because in either case, the powers would have to be limited. And it seems that the powers, the amendment power and the ordinary legislative powers, the difference is not so much a difference in kind, but rather it's a difference in the degree of power that the two powers. So what about the practical implications? I've got other questions as well. Can I ask them as well?
Yeah, of course.
Okay. The second question that I've got is about the spectrum theory in your book. I'm absolutely fascinated by the spectrum theory, which you didn't manage to talk about in your lecture. But basically the idea is the more similar the democratic characteristics the amendment powers are to those of the primary constituent power, the less it should be bound by limitations. So that's the spectrum theory. Amendments introduced by a referendum, for instance, should be subject to fewer limitations than amendments introduced by just an ordinary legislature, for instance. My question is, to make that assessment, how similar the amendment power is to the original constituent power, we need to have an idea as to what the original constituent power is. What is your idea? Is it some kind of Athenian democracy, people gathering to some kind of direct democracy discussing amendments? How similar would a referendum, a normal referendum, say in Switzerland, be to an original constituent power? And would participation rates, so that only 10% of people voted in the referendum, affect the degree of similarity with the original constituent power? And related to that question is, for constitutions that seek to make provisions for the reassertion of the original constituent power, are we then allowing the original authors of the Constitution to dictate what the constituent power in future looks like? And well, also final remark, have you thought about further particularization of the escalator? So currently in your book, the proposals seem to be binary. So if an amendment is introduced by a governmental institution like a legislature, then courts should apply the disproportionate violation sentence. Basically, they should be more rigorous in reviewing it. Whereas if it involves some kind of popular amendment like referendums, then courts should be more relaxed, more deferential. Have you thought about further particularization such that it will really be a spectrum, an escalator, rather than just binary?
Shall I answer now?
Do you prefer?
Yeah, okay, let's do that.
Maybe,
Okay,
okay, sure. Yeah.
Good, so these are indeed great questions. Okay, so let's start with the first one. The practical implications. Well, I think that even before going to the practical implications, just let's go back to the theories. So according to the story that we all tell ourselves, there's a constitution-making power that creates the constitution. The constitution in turn creates all the constituted organs, yes, legislative, judiciary, executive, etc. And then the constituent power, in a way, retires into the clouds. It disappears, and all public powers from that on are exercised according to the constitution. And what role does this give to the people? Where are the people? So it seems to me that the people are in a way represented by the amendment provision, by the amendment formula. Through the amendment formula, the people can in a way control the constituted powers. So I didn't want to say, and I don't think the amendment provision is an ordinary constituted power, because it can change other constituted organs. It can decide, it can change the powers of the parliament, it can change the power of the judiciary and of the executive. It is a special kind of power. It is higher than the other regular constituted organs. So I think that the fact that it represents the people in a way, or represents their constituent power, because juridically the result is the same. If you exercise original constituent power, you have new constitutional norms. If you exercise derived constituent power through the amendment procedure, you can have new constitutional norms. So juridically speaking, the result is the same. So it can't be ordinary constituted power. It has to be something special. But I didn't want to equate it with original constituent power, because it is still a legal competence. Therefore, I thought that I should make this double distinction. And of course, the practical implication is the limited power of that ability to amend the Constitution. That's the practical implications. And of course, that it, to my belief, should be subject to judicial review. Just as an ordinary constituted authority has a certain jurisdiction that it cannot overstep. Likewise, the amendment authorities have certain limitations that we, the people, have not granted them in the Constitution. The second is the spectrum theory and the escalators. Yes, so you're very much correct. So I didn't talk about it because I didn't want to take too much time, but I think that there are two issues that are extremely important when we are amending the Constitution. The first one is legitimacy-wise. And I don't think that when Parliament can amend the Constitution through an ordinary majority, or even a special majority, I don't think it carries the same legitimacy as amendment procedures that include elections to constituent assembly and there some kind of affirmation through a popular referendum. So when the people are actually involved, this carries greater legitimacy. And because it carries greater legitimacy, I argue that the scope or the ability to change the Constitution should be greater than ordinary procedures that simply give Parliament just as in the same procedure as ordinary legislation. They should be able to amend the Constitution. The second thing that supports this legitimacy argument is the fear of abuse. And the problem is this. Imagine to yourself that Parliament enacts an ordinary legislation that, let's say, allows torture. And then the court declares this law as unconstitutional for violating human dignity, or the constitutional right to dignity, or the prohibition on torture. And then the Parliament, because it has the authority, uses its authority to amend the Constitution and includes a notwithstanding clause within the Constitution that says, notwithstanding the article that protects human dignity, governmental authorities have the power to torture suspected terrorists, let's say. So my fear is that the easier the amendment procedure is, the easier it is, or the more tempting it would be to try to abuse the amendment power and misuse it, just in order to shield that provision from judicial review, in a way. Now, in contrast, if in order to amend the Constitution, you need to go through a constituent assembly that will sit and discuss this amendment and then bring it to the people, then I think there's less chance for an abuse. So, and here you're right about my vision of original constituent power, because you need, I state in the book that the closer or the more resemble the amendment procedure is to original constituent, the appearance of original constituent power, the less it should be limited. Now, there is no such thing as original constituent power. It's a myth. Obviously, the people are never gathering to speak about the Constitution. But what I have in mind is a democratic conception of constituent power that has three characteristics: inclusiveness of the people, deliberative, must be deliberative, and time-consuming. Time-consuming in the sense that it would object temporary majority to abuse their powers. It must represent, in a way, a supra-temporal or supra-generational understanding of the people. So one-time referendum, like Brexit, is to my mind not an expression of true constituent power. But if you have one referendum and legislation by the legislators, and let's say in the next parliament or the next few years, you have an additional legislation followed by another referendum, and both are, have the same results, then this is a better manifestation, I think. So these three conditions must be applied with: inclusiveness, deliberativeness, and time-consuming. That way you won't be able to abuse the amendment procedure, and you will be able to give more legitimacy to the thought and change. There's a question on escalator and spectrum.
And also, well, allowing the original authors to dictate what the next.
Yes, so this is the third. Yeah, so this is the third point. So now this is what we find in some new constitutions. They try to stipulate not only the amendment procedure, but also the procedure of how to have a new constitution. So these constitutions state, if you want to have a new constitution, you need to have elections to the Constituent Assembly, blah, 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 according to Article 345. Now this is, of course, ridiculous, because you cannot legally confine the constituent power, which has extra constitutional features. But what you can do, you can stipulate that in a provision. And if you want to grant some legal legitimacy to the act of new constitution making, then you can follow this provision. So the original constituent power does not have to follow that provision, but it can do so if it chooses to follow that provision. And this, of course, raises another question that I'm not dealing in the book. Is the people, or is the constituent power, the original constituent power, limited in any way? I don't touch this book, but this is, of course, a very strong question, because what we see nowadays is totalitarian leaders who say, oh, I have limitations in amending the Constitution, no problem. Then, like Napoleon said, yeah, je suis le pouvoir constituant. I represent the constituent power, and I now have a new constitution, and that's it. And then I override the limitations. So I believe that the original constituent power is also limited in different ways, but that's a different project.
Thank you. Questions?
Thanks very much. Thank you, Yaniv, for a really interesting talk, and I'm looking forward to reading the book, which congratulations also on the success. I'm curious with this trend that you identified at the outset of the presentation today, which is sort of an apparent trend towards unamendability, at least in the de jure sense. So having, because you've had your head in this topic in such an in-depth way, I wonder what your intuitions are about what explains that trend. And so let me just propose three ideas, and I'm curious about what your reaction might be. So one, which you kind of flagged, was that Germany is just sort of trendy in constitutional thought, with the declining influence of American constitutional thought around the world. We see a sort of trendiness of all things German. So maybe it's just that, it's fashion, as you said. Another idea might be that it reflects some kind of ideological shift towards something more along the lines of natural law, so kind of paralleling a move from constitutional rights to human rights being somehow transcending positive municipal law. And then the third one I wondered about was whether having looked around at all these different examples, do you see something there in terms of just, and this is actually, you sort of suggested this with your Locke analogy, is there something there in terms of distrust, and the sense that democracy is more competitive? So if you're part of a constituent assembly or a group of whoever is deciding on the constitutional text, and you think that you might actually have competitors who might emerge in the next foreseeable future to challenge this constitutional moment with their own. Maybe you try to hedge against that with this unamendability device. So these three ideas aren't mutually exclusive. Maybe there's something there in all of them. I wondered what you thought, having looked at all these examples.
Thank you. In the interest of time, maybe I'll David.
Sure.
Question. Maybe I'll take David's question.
Are we ending at one? Is that the end? We're wrapping up one
round.
So I don't know how much of this is a question, but just to take a step back from this for a moment, right? So this is in the area of what I've heard described as amendment theory, which is, I guess, a hot area now, comparative con law. And I guess it's more on the law side than the social science side. And what it reminds me of, so there's this interesting logical puzzle. Why else would Goodell get interested in it? Right? It reminds me of the debate over parliamentary sovereignty, which also raises interesting logical issues. Can Parliament limit its own sovereignty? Can the United Kingdom ever really give up sovereignty over Australia and Canada? And here's why it reminds me of this entire debate raises for me the question of what purpose does amendment theory serve in a practical sense? Because yes, the issue, by way of analogy, the issue of parliamentary sovereignty raises all kinds of interesting theoretical questions about whether the United Kingdom Parliament can do X or Y or Z, right? Whether it can disown itself from Australia or Canada. And so if one approaches con law or public law as an exercise in applied philosophy, that's a fascinating problem. If one approaches law from a realist, Oliver Wendell Holmes, the life of the law is not logic, it is experience, what really happens point of view, it's completely uninteresting because the UK can never possibly reassert sovereignty over Australia or Canada, no matter what the theoretical argument might be. And the problems with theoretical arguments extremely hard to meet, right? The parliamentary sovereignty argument. Okay, so jumping back to amendment theory. So we have this logical puzzle, which is, well, how can there be such a thing as an unconstitutional constitutional amendment? How can there, or the flip side of that is, how can there be limits on the power of the constituent power to remake the Constitution? And is the answer simply the same, which is that none of it matters? And law is not applied philosophy. It's really, constitutional laws, constitutional politics. What the UK Parliament can do, regardless of the theory of parliamentary sovereignty, is dictated by constitutional politics. What can be done in terms of amendment or non-amendment is again dictated by the theory of constitutional politics. And to the extent that any of this is relevant, any of this amendment theory is relevant, it is in the sense of arming courts with arguments that may or may not be considered persuasive because courts uniquely have to rely on persuasion in trying to get what they want. And even then, it's a very weak kind of medicine, right? So I guess it's a large, putting amendment theory itself in context. How big a deal is this? Is this the equivalent of the debate over parliamentary sovereignty, the paradox of omnipotence? It seems like a big deal, but on closer examination, it kind of dissolves the practical matter. I know that's a big, sprawling thing.
Okay, all right. Yeah. Okay, so I'll start with Alex's question. Thank you, Alex. Yeah, you have a good point in your suggestion. I think that there's this amalgamation of reasons. So the first, the one you said last, I think, is the way that majorities or current majorities try to just shield their contemporary superiority. That's a very interesting and valid point. If you look at France, so one of the earliest examples of unamendable provisions comes from France, and the French in 1884 they amended the French Basic Law, the 1875 Basic Law, and they inserted the provision that says that the Republican form of government cannot be amended. Now, why did they choose to do it? Because there was a battle between the Republicans and those who wanted to go back to a monarchy. And because the Republicans had a majority at that time, they said, no, now we're going to shield our preferences in the Constitution in a way that you cannot change it, even if we will become a minority in the future. So obviously, one way to use this provision is simply to shield your own, your majority preferences in case you'll become a minority in the future. That's indeed, I think this is one thing. The second thing, which also relates to distrust, comes from the idea of a militant democracy. Right? So post-World War II, there was this conception that democracy has to protect itself. So, like banning certain political parties that aim to abolish the constitutional order, likewise, unamendability represents or expresses what I call amendophobia, the fear that you will use the amendment provision in order to undermine democracy itself. So therefore, if you look at what is being protected, most of the things that are being protected are those essential features of the democratic order. Democracy itself, or the rule of law, separation of powers, etc. So this is the second explanation. Another explanation could simply be what Levi-Strauss called bricolage. You just take from what's ready in hand. So also when you write a constitution, you don't try to make up things, you just look around and see what's going on. So in the early years, in the first wave of constitutionalism, if you look at unamendable provisions, what you basically see is imitations of the French and American constitutions. Protection of republicanism, or laïcité. These are post-colonials, French post-colonials, they protect laïcité as well. So republicanism and laïcité, and federalism and equal representation of state. Because this is what we had in the US. So that's simply boring, constitutionally boring in a way. The third character, I believe, is transformative. What you see is basically in those societies that have been transformed, either new states or after revolution, what they try to protect, and that's a negative understanding of constitutional, what they try to protect is the evils of the prior regime. So in African or Latin American states, the usually protected constitutional rule is presidential term limits, simply because in the past the presidents were trying to perpetuate their stay in power. So you have term limits. That's why in Germany they protect human dignity in light of the Holocaust, etc.
Pausing there for, I've noticed that in the book you used Hong Kong as an example for the transformative section.
Yes. Yeah. So I think that there is this example of new, let's say, not exactly new, but new legal entities. And you try to use unamendable provisions in order to protect these the basic features of these entities. So the same. So in Hong Kong, obviously, the basic policies must be maintained. So we try to limit the future legislation power of the Chinese legislator. And likewise in Cyprus, when they established Cyprus, they protected the basic principles of the international agreement in the constitution. So this is a more preservation understanding. So the transformative is another character. And the final one that I think that can explain this trend is that you can use these constitutional mechanisms to solve conflicts, overcome conflicts. I think the most famous example is actually the American one. So in the US, when they had formed the Constitution, the original Article 5 included a provision that states that you cannot abolish slave trade prior to 1808. It was an explicit limitation on the amending power itself, because they were feared that if they would have to open it now and decide it, this might ruin the entire constitutional project. So they say, let's silence this, that's a gag rule, let's silence this project for a while, this issue, because it's too contentious now. We'll solve it in 10, 20 years. So likewise nowadays, you can use unamendable provisions to shield things that are too contentious. Well, we can't decide on this issue, let's leave it untouched for a while, and or forever, let's say, until we have a new constitution, and then we can continue with our joint project that's called the Constitution. So I think all these can explain this recent trend. And the question about natural law is interesting. Yes, I think in a way there is this conception that certain things have a supra-constitutional status. They are above ordinary constitutions. So even Emmanuel Joseph Sieyès, the father of the idea of constituent power, wrote that the nation is law itself. It can do whatever it wants. It's law itself. Sieyès finished that sentence by saying, above the nation, there is only natural law. So even Sieyès understood that natural law, his conception of natural law, is above the constituent power. And I think, yes, and specifically if you look at human rights and post-World War II, in the past, prior to World War II, only 2 constitutions protected fundamental rights in an unamendable provision. Nowadays, I would suggest it's slightly over 20% of all constitutions that protect fundamental rights from being amended. Now, I want to refer to David's point because it's very important, the idea of constitutional politics. And I actually want to connect David's observation to a more recent trend, what we see nowadays. What we see now in global constitutionalism is that courts have taken this doctrine, they see what other courts do, the way they manage to protect certain principles and to elevate their power vis-a-vis other governmental branches. And we see leaders that have realized that they have a limited power to amend the Constitution. So what they do, they now try to abuse or misuse this unconstitutional constitutional amendment doctrine to promote their own agendas. And I'll give you just two recent examples from Nicaragua and Honduras. So the Honduras Constitution had as the keystone the protection of term limits. There could be only one presidential term, and that's it. Okay? Now, and this was a very strong protection. It was unamendable. You cannot touch it in the Constitution. And it also included another provision that says that even if you want to try and change it, this provision, this term limit, you'll be out of office immediately. if you only propose to amend it. So in 2009, President Zelaya, he said, well, he didn't propose. He said, why don't we have a referendum to see whether the people are interested in having a new constitution without these presidential term limits. But the legal advisors and the court said that this is a violation of the unamendable provision and the term limit, and the court gave a decree to put the president down, and the army came in the middle of the night taking Zelaya out in his pajamas. And so some would claim that this is a coup d'etat, not surprisingly in light of the history, but it only demonstrates the strength of this unamendable provision. And what we see nowadays, what happened is that the court received an appeal, a challenge to the term limit itself, the original provision in the Constitution, stating that this constitutional provision should be declared as unconstitutional because it violates other constitutional rights, such as the right to be elected, the right to vote, freedom of expression, because you can't even propose to change, etc. And in a recent case, in 2015, the court declared that provision as unconstitutional. By using the unconstitutional amendment doctrine, it used it to declare the original provision as and now the president can run again for office. And this is, I open brackets here, this is the captured courts. The president more or less controls the court. So the court, if we talk about constitutional politics, David, the court now take this doctrine, which is well established in some states, and misuse it to promote different agendas. Instead of protecting democracy, now it undermines democracy by using this doctrine. And the same occurred in Nicaragua. Exactly the same. So nowadays, in these two states, that the presidents have used this doctrine to promote their own agendas to be able to be re-elected. And that's, of course, a big problem. And we have now a current project that I'm working on with Rose Dixon and David Landau on how we can fight this, what we call doctrinal capture, the courts capturing this doctrine and abusing it. So that's a good point you've raised here.
It's one. Do we have any pressing questions? We'll take one final question. Yes,
because the way Yaniv, you the way you presented your theory, it makes me to question whether actually your theory applies to subnational constitutional instruments, particularly in relation to your reference to the original constituent power. Bear in mind that the original constituent power and the central authorities always has the authority to regrant a new constitution to the lower subordinate region.
I think that's a great topic. You're right. I didn't delve into it in the book. So we're talking about subnational entities within federal states. So what is interesting that you find, if you look at the U.S., and I'll be very quick in my answer, if you look at the U.S., you will find some states within the U.S. that have in their constitution certain things that are considered unamendable. These are things that represent we the people in the small subnational state. So I think it definitely makes sense, and it could be applied even to subnational entities in a way, but conditioned by the fact that they are always conditioned by these conditions and stipulations that appear in the either federal or national constitution. So, but I think if you go to the people in Texas, you have "we the people," they would see themselves as "we the people" that carry some basic features that represent their identity. So I think at least many aspects of the theory are applicable to my mind, but I'll need to further think that through.
Thank you very much. Please join me in thanking Dr. presentation and very, very provocative and intellectually stimulating questions.
Thank you for hosting.
Thank you very much. Thank you. Thank you for attending.